Welcome, everyone. I'm Alicia Smith, and I'm the Executive Director of Dyslexia Canada. Dyslexia Canada is a national charity, and we're committed to ensuring that every child with dyslexia in Canada gets a fair and equitable education. And that's why I'm very excited to be able to bring tonight's presentation to you, Defending Your Child's Right to Read, Understanding Your Legal Options. And tonight we have two fantastic guest speakers who are going to help us explore this topic and answer all of your questions. Our speakers are Wade Poziomka and Nicole Biros-Bolton. So welcome both of you and thank you for joining us. Before we get started, I'm just going to do a quick introduction for Wade and Nicole. Wade is a lawyer who has dedicated his career to ensuring that the voices of marginalized members of our communities are heard. Wade obtained his law degrees from the University of Toronto and Cornell University. He's the past chair of the Ontario Bar Association's Constitutional, Civil Liberties and Human Rights section, and sits on the executive of the Canadian Bar Association's Constitutional and Human Rights section. He just completed his maximum term as first vice president of the Board of Directors of Arch Disability Law Center, and is a current director of the Niagara Community Legal Clinic. Wade passionately advocates for his clients, and his practice is dedicated to human rights, union-side labor law, and employment law. Welcome, Wade, and thank you for joining us.
Thank you very much for having me.
Thanks. And I'll introduce Nicole. Nicole is a feminist social justice lawyer who brings over 20 years of experience working as a frontline counselor and advocate for women, children, and gender diverse individuals who've experienced violence, trauma, and abuse. She believes that justice and equity are non-negotiable and always worth fighting for, and she pursues these goals with empathy and compassion for her clients. Nicole holds a law degree from King's College London, UK, and a master's in human rights law from the University of London, UK. She's a board member for Parkdale Community Legal Services, and she's a member at large of the Ontario Bar Association and Constitutional, Civil Liberties and Human Rights Executive. That's a mouthful. So welcome, Nicole and Wade, and thank you so much for volunteering your time to prepare this presentation and answer all of our questions tonight, of which I know there will be many. So for those of you who are joining us tonight to listen to the presentation, please put your questions for Wade and Nicole into the chat, into the Q&A function using the Q&A section at the bottom of your screen. If you have a comment that you'd like to share with the other participants joining us tonight, please feel free to use the chat function for that. The same is true if you have resources to share. If there's something that you would like to share with the other people who are joined to listen today, feel free to put that in the chat. And if there are resources that are shared, I will pull those out of the chat and send them to everyone in a follow-up email tomorrow. So without further ado, I will turn it over to Wade and Nicole. Thank you very much.
Thank you very much, Alicia. After hearing an introduction like that, I feel like it sets the bar very high, hearing about all of our past achievement. And now, if we don't perform to that level, we fail miserably here today. So let's hope we don't fail. Very brief introduction. So education is vitally important to a person's development and will ultimately impact an individual's ability to take part in the labor market, realize their full potential, and participate meaningfully in society. Engagement in secondary school is related to an individual's likelihood to attend post-secondary school and achieve success. Notwithstanding all of the strides that we've made in Ontario, there's still significant problems. And the Ontario Human Rights Commission notes in its policy on accessible education for students with disabilities that disability is the most cited ground for discrimination claims in Ontario at the Human Rights Tribunal. And it's not only the most cited ground. I was on the Human Rights Tribunal's Practice Advisory Committee in the past, and so I used to see these statistics in the practice statistics and issues that we're developing of the Human Rights Tribunal, and disability is by far the most cited ground at the Human Rights Tribunal. Usually it's in employment, but services is quickly growing. Statistics Canada reports that Ontarians with disabilities continue to have lower educational achievement levels, higher unemployment rate, and are more likely to have low incomes than people who don't have disabilities. I put the policy up here. Many of you have probably already seen it. It's a comprehensive policy. There's a link to it. I will make the PowerPoint that Nicole and I are sharing with you tonight available to Dyslexia Canada to share as well following the presentation. So if there's links and case citations that you need, you'll be able to find them in there. So our presentation will focus on human rights. And I just want to be clear from the outset that the Human Rights Code is not the only mechanism to address things that happen in education. The Charter applies to education and to schools as well. The Education Act applies. My experience in our practice area is with the Human Rights Code, and the Human Rights Code in the Human Rights Tribunal is where most of the developments in education are happening. So we'll start with a human rights primer. So that will just be an overview of the human rights process, how it works, what discrimination is, what the duty to accommodate is. Then we'll look at the actual process itself. So the application, the response, how do you file an application with the tribunal? What can you expect when you're in that process? I'll talk a little bit about timelines. Those have changed drastically over the past 3 or 4 years. And these are all things you should be aware of before deciding whether the human rights route is the right route for you to pursue redress against a school board. We will look at human rights then specifically in relation to education, and we'll go through some notable cases. And then after that, I want to talk about arguments that I see from school boards often. So what are the obstacles that school boards present when you're bringing a human rights application, and how can you respond to those? So, this is really based on my experience and based on the case law, and I'll give you some of my views on that, and Nicole as well. Then we have a couple of frequently asked questions that we'll address, and then of course we'll take your questions, and hopefully we'll be able to answer those. So let's jump in with the human rights primer. The Human Rights Code applies to 5 social areas. Employment is the most common social area that we see human rights claims brought in. The next being goods, services, and facilities, and education falls under services. So when you're thinking about is something a human rights violation, it has to fit into a social area. So one of these 5. It can't be someone's walking down the street and someone makes a comment to them and that's a human rights violation, because it's not within one of these social areas, even if that comment were discriminatory on its face. So if it's not in these areas, it's not a human rights issue. And oftentimes what happens at the tribunal, and part of the reason for backlog there in the delay that we're experiencing now, is that people think issues of general unfairness are human rights issues. And so a lot of applications get brought in the initial stages, and it kind of gets caught up in the process and ultimately dismissed, and causes some of that backlog. So again, we have to have it in one of these 5 social areas, and it has to be on a protected ground. Most common ground, as stated, is disability. We see age claims that are becoming more frequent, family status claims, creed. In terms of education and the types of things that the participants to this seminar will likely be dealing with, disability is obviously the primary ground, but family status is another ground. So where a school board may say, well, the reason we're not engaging with a parent, and the reason we can't offer this or that accommodation, or the reason that there's a lack of communication, is because of aggressive parents. And they'll point the fingers at families who've become frustrated with that lack of accommodation. So family status is another important ground to keep in mind as we go through this presentation. So again, has to be in a social area, one of the 5, and it has to be on a code protected ground. Disability, the disability ground in the Human Rights Code has a very broad definition. So you see here, this is a definition, part of the definition from the code. It's actually larger than this, but it includes a developmental disability and a learning disability. And basically outside of kind of what we're dealing with today, anything that could be a WSIB claim, somebody gets hurt at work and they could be off work under the WSIB system receiving pay, would constitute a disability. So very, very broad definition. The way to think about this typically is when I'm talking to my clients and they're saying, does this constitute a disability? Is it something greater than a common cold or the flu? Here's the test for discrimination. So establish that there's a characteristic protected from discrimination under the code. So those are the grounds. So something arising as a result of disability or family status, for example. Then the second step is establish that there's an adverse impact in one of the social areas. So something bad has happened in education or in employment. And then the last step is connect them. So show that link. Establish that the code protected characteristic was part of the reason for that adverse impact. A lot of the times you'll have number 1 and 2 in the fight at the Human Rights Tribunal will be around that link in establishing that they're connected. Different forms of discrimination. Direct discrimination is probably what most people think about when they think of a human rights violation. If if someone says, I'm terminating your employment because of the color of your skin, of course, that's direct discrimination. Systemic discrimination is discrimination that's embedded in policies. It's kind of more invasive in an organization and often harder to detect, but you can see the outcomes of it and often harder to prove. The most common form of discrimination that the tribunal deals with by far is constructive discrimination. And I'm going to give you an example of constructive discrimination because it's important to understand this. A lot of employers, a lot of school boards have failed to understand this in the past. So let's assume for a second that we have an employment situation and there's a call center. And in that call center, there's a policy that the call center adopts. And that policy is every person working here on the floor has to make 800 call minutes per month. Joe only makes 740 call minutes, so he falls below that threshold and he's fired. And Joe says, okay, well, the reason I didn't have 800 call minutes was that I have cancer and I was undergoing cancer treatment for 2 days of those months, or so 2 days of that month. And otherwise, had I not have gone and missed work because of that cancer treatment, I would have been here for those 2 days and I would have exceeded the 800 minutes. And so it's unfair that you fired me. It's discrimination. Employer in this case said, well, no, we have this policy and it applies equally to everybody. So it doesn't, we don't care if you have cancer. We don't care if you slept in, whatever the reason is, you got to make 800 call minutes. It's not discrimination because we don't care what the reason is. And that, in fact, is the definition of constructive discrimination when you have a policy that applies equally to everybody, but it impacts somebody differently because of a code protected characteristic. So yes, this policy applies equally to everybody, and it might be fine in certain circumstances, but with respect to Joe has cancer, and that's a disability under the code, and he didn't meet the criteria because of that. And so there's no intention to discriminate. Of course, they didn't think when they're drafting the policy, we're going to get people who have cancer, but it has the effect on Joe of discriminating. This is an actual case that I argued. The facts are a little bit different here for the presentation, but it's a previous case that I argued at the Human Rights Tribunal. So Nicole's going to talk a little bit about the duty to accommodate next.
Yeah, hi everyone. So first of all, I thought I'd just explain what accommodation means, because sometimes that can be a bit of a legal term, and really all it is in the context of education, at least, it's the school or a service providing as much help and assistance for somebody who may be limited by a disability, for example, from accessing the same services in the same meaningful way as everybody else is able to. And there are limits to that. So I'll talk about that a little bit. So first of all, there are two elements to the duty to accommodate. One is substantive and the other is procedural. So really the procedural part of the duty to accommodate is really the steps that the school, in this instance, if we're talking about education, the steps that the school takes in assessing what the accommodation is that is needed. So that might be inquiring about information, asking for assessments, looking into more detail so that they can make an assessment rather than just say right off the bat, no, I'm not giving you this accommodation. So really considering it and being thoughtful about it. That's the procedural part. The other part is the substantive duty to accommodate, which is really the accommodation itself. So what is provided, what is the substance of the accommodation that is offered? And The three key principles that drive the duty to accommodate are the respect for dignity of a person, individualization, which really means just tailoring the support or the accommodation to the individual needs of the person that is seeking it, and also integration and full participation. So like I said, accommodation is about giving someone the tools that they need to be able to access the service in the same way that others do, to the point that they can. And that's really where we're going to get into undue hardship on the next slide, Wade. So undue hardship just means that, you know, there are limits to what service providers, and in this case, schools, can provide and offer. They're not expected to give anything and everything. There are limits to what they are able to provide, and so the law sort of recognizes that through undue hardship. So the three considerations that are made are for cost. If something's incredibly expensive, then it might qualify as undue hardship. If outside sources of funding are available or not, and the health and safety of everybody. So if those things come into play, then the education system might be able to say, well, this is undue hardship, but there is still a clear requirement that they explore those possibilities and make efforts to provide accommodation wherever possible. And that means being creative and finding ways that avoids too much cost or something like that. The other thing I'll say just about accommodation is that it is really important to remember that the expectation is that both sides are working together in partnership to come up with a solution. It isn't meant to be a fight or an argument or one side doing all the work versus the other. So there still is an onus on the person seeking the accommodation to make efforts to participate, to cooperate, to provide information, and to also be flexible.
And I'll just say here, under undue hardship is a very, very high threshold to meet. So cost, if you look at some of the case law around cost, it talks about bringing an organization to the brink of not being financially sustainable any longer, so bankruptcy. It's not quite that high. I'm picking some outlier cases, but the point I want to make is that cost is a really, really high threshold, and health and safety has to be, you have to try to alleviate those risks before you can hang your hat on health and safety. In my view, in education cases, in my experience, you won't typically find a lot of the arguments and the disputes around undue hardship. You'll find it around whether something's a service. So in one of the cases we'll talk about just a little later, we'll see that the Human Rights Tribunal said applied behavior analysis for a student with autism spectrum disorder is not a service that a school board provides. And so they fight it in that initial stage. You don't often see it around undue hardship, but if you do, generally speaking, it's a really, really high threshold and something that's tough to be successful in for a school board.
But probably equally, I think school boards, employers, any sort of respondent within the human rights process, I see it. I think it's easy for them to go there. So I think they'll still try and say it was undue hardship. But of course, perhaps they won't be successful. So yeah, on to remedies. So possible remedies that you can seek when you apply to the human rights with a complaint. There's a range. So one is special damages. So that would be if you were employed and, for example, had to go on a leave and couldn't return to work because the employer wasn't accommodating you or was being difficult about your return to work. That you could claim lost wages if you were wrongfully terminated, for example, again, lost wages. But I guess this could also go into therapy costs. So if you needed to pay for therapy for your child, for example, as a relation, as it related to the failure to accommodate within a school setting, that would be special damages. And also then well worth keeping receipts in advance of all those things. General damages really speaks to the pain and suffering that an individual goes through discrimination. So general damages are tax-free. There's no T4 issued. It's really just to recognize the pain and suffering that one has been through. There's also non-monetary remedies. And I'm drawing a blank right now because public interest remedies. Sorry, Wade, what do we mean by non-monetary?
So non-monetary can be things like training in an organization or developing a policy or posting a policy, that type of stuff that doesn't have the financial component attached to it.
Yes, thank you. Sorry, I would have put that into public interest remedies, like big policy changes that you might want. But yes, so true. So you might want, for example, if you're dealing with a school and the teachers just don't seem to have an awareness about the duty to accommodate, or an awareness of discrimination and disability and the things that they should be doing versus the things they shouldn't be doing. Maybe it's really important to you that the school gets an expert to come and provide training on that, and give insight into, look, these are the things you should do if somebody comes to you and seeks accommodation. How can you appropriately respond? Perhaps that's going to be helpful to everybody, so that's something you can ask for. And similarly, maybe they need better policies in terms of how they respond.
Just one point here on general damages. When someone's bringing a human rights application, one of the questions we consult a lot with individuals who are filing, but they don't necessarily want legal representation at that point, or they can't. There's reasons why they're going to proceed on their own. A good general damage number we're seeing in human rights cases is $30,000 to $35,000. There's been some awards from the tribunal in that range recently. General damages across the board have been going up. What I would say and recommend is don't put $1 million. That's what some people do, or $5 million or whatever, because they feel the moral harm justifies that, which it's hard to put a number on the harm you've experienced. But having said that, it has to be grounded in the tribunal's case law. So that doesn't mean you put $30,000 or $35,000 because that's what they're ordering. I always try to drive them up. So Nicole and I, when we're looking at human rights applications, we'll put somewhere around $75,000, just trying to drive that number slowly up and come in with a credible number the tribunal might consider.
And sorry, and just to add to that, because Wade, you and I had talked about this the other day, and you made the good point that certainly in sexual assault or sexual harassment type of cases, the tribunal is more likely to award a higher amount. And so for those, I would say, ask over 100,000. Not that you would necessarily get that, but as Wade says, drive higher.
Yeah. So let's talk a little bit here about the human right, the process, the procedure of the Human Rights Tribunal. So we know now what discrimination is. We know about the duty to accommodate, the procedural and the substantive components. We know about undue hardship, and we know about remedies. So here's what you do if you believe you have the service area being education and that your child's experienced discrimination on a code protected ground being disability. You can file an application with the Human Rights Tribunal. So it's a form you fill out. Usually you'll type out a Schedule A attachment, and you'll explain exactly what happened with as much detail as you can. It's better to be more detailed than less detailed in that application, because there's procedural issues that can come up down the road. We won't get into that, but just be more detailed. Once you file the application, which is free to file, it goes to the Human Rights Tribunal, and the Human Rights Tribunal only. So they'll vet it. And once they look and they say, oh, this is complete, we don't have any preliminary issues with it, the Human Rights Tribunal will then send it to the school board. And they'll give the school board a time frame to respond, 35 days typically. The school board responds, which is the response. That goes to the Human Rights Tribunal, doesn't go directly to you. And again, the tribunal vets it, and then they will send it to you. And then you file a reply. So you read the response, you see all the terrible lies the school board said, and you reply to them. And you send that reply directly to the tribunal and directly to the school board. The next step is, if both parties have agreed to this, mediation. It happens a lot. So most of the time, both parties agree to mediation. It's a free process. It's offered through the Human Rights Tribunal by a human rights adjudicator. It lasts for 3 hours typically. Sometimes in education cases, it will be a full day. And it's an off-the-record opportunity to have a discussion with an adjudicator in a mediator role to try to help the parties come to a settlement. So often money's involved, but it generally speaking, in these types of cases, it's much more than money, right? Because we're looking for accommodation or some service that's not being provided that we want provided, or a grade that might not be reflective of somebody's ability because they weren't properly accommodated, removed, or changed. Those are all types of things that come up in mediation frequently. The mediation is, as I said, voluntary. So if you're in the mediation, you spend an hour and the school board's not working cooperatively, you can end that process and there's no consequence for doing that. You stay in the tribunal process and you move into the hearing queue. So after a mediation, if it's successful, of course, the process ends. If it's unsuccessful, you'll deal with any preliminary issues or a summary hearing. Sometimes there's timeliness issues. One important thing to remember about a human rights complaint is that you have to bring it in within 1 year. There's some exceptions to that, but the test is really, really difficult. And so if you just make sure you meet that 1 year period from the date of the discrimination. And the date of the discrimination could be, for example, an expert or a specialist says, okay, a child requires this accommodation, the school board says no. Okay, well, now when they say no, the clock is ticking, and you want to make sure you file within a year from that date, or a year from the time that you asked if they've dragged it out and there's delay that's part of what you're alleging as the failure to accommodate. So after that, you'll receive a notice of a merits hearing. So what that will be is that on such and such a date, at such and such a location, at such and such a time, your hearing will be held. Now that triggers some important timelines. So about 21 days after you get that notice of merits hearing, you have to produce arguably relevant documents. This is really important. So you have to give them the documents from your case that are arguably relevant, and the school board has to give you the documents from their case that is arguably relevant. And after you get those documents, you want to sit down and go through them and think, okay, have they produced everything that is relevant, or can I think of things that matter for this case that they haven't produced? And that's often the case. In probably 80% of cases, you'll think of something, okay, they should have given me this or that. You want to write to the other lawyer, and you want to ask that lawyer for these documents. I believe these exist. I believe they're arguably relevant. Please provide them. If they don't provide them and you can't get an agreement, then you want to file a request for an order during proceedings. So this sounds really complicated, but it's actually quite easy from a procedural perspective. If you go on the Human Rights Tribunal's website, you'll find a Form 10, request for an order during proceedings. That's the form used for most things that you want to bring a motion for or ask the tribunal for something for. And you'll file that saying request for production of documents, tick the box, and just list what you think they have and why it's relevant. And you send it off, and they'll have to respond, and the tribunal will deal with it as a preliminary issue. After you get past that stage, 45 days before the hearing, so about a month and a half, everybody goes through the documents that they produced, and they pick the documents that are relevant. So what are they going to use in the actual hearing? And they exchange those with each other. And they also exchange witness statements in a witness list. And then 45 days later, you're at the hearing. Practically speaking, the vast majority of cases in education and outside of education settle. So you'll only find about 5 or 10% of cases ever make it to a hearing. So statistically speaking, there'll be some resolution during the process, including sometimes on the first day of the hearing. Okay, so let's look at human rights and education. So the service being provided is not special education, it's just education. And what the Human Rights Tribunal has said, and what we know, is that the Human Rights Code has primacy over all other legislation in Ontario. So legally speaking, they call it quasi-constitutional. What that means is that it's a little bit more important than other pieces of legislation because it's protecting human rights. And so it's expected and assumed that school boards will implement the Education Act in accordance with the Human Rights Code. And so we see from the Moore decision, which Nicole will speak about in a moment, that if the evidence demonstrates that the government failed to deliver the mandate and objectives of public education such that a given student was denied meaningful access to the service based on a protected ground, that this will justify a finding of prima facie discrimination. So the test is, the service being provided is education, and the test is the student being provided meaningful access to that education? And it's important to look at the purpose of education, because you can get into situations where something that a parent or a family is seeking is not a service within education. And so the definition of education, the purpose of education, is found at section 0.1 sub 2 of the Education Act. And again, we'll make this PowerPoint available for everyone. Part of what Nicole and I tried to do when we were putting this PowerPoint together for you over the past week is put in some quotes and some section numbers, not because we want to bore you with legal things, but because we anticipate that some of you may be advancing your own human rights application. So we're trying to give you quotes that you might need to put into that application, sections you might need to reference. So we're trying to make it a useful guide in case you do have to go through that process on your own. So Section 0.1 sub 2 of the Education Act tells us that education is to provide students with an opportunity to realize their potential and develop into highly skilled, knowledgeable, and caring citizens who contribute to their society. Human Rights Tribunal goes a little bit further. So in DB, they say that the purpose of education is to provide students with the opportunity to realize their potential and develop into highly skilled, knowledgeable citizens who contribute to their society by acquiring specific skills and accessing the available curriculum. And that's important because to establish discrimination, we have to look at what is education. And if you look at a case that we'll look at shortly, the LB case, in that case, the tribunal found that applied behavior analysis was not a service in education. So it's important to understand, and you see in the DB quote that they're really kind of confining it to accessing the available curriculum, and we know in a meaningful way. So it's important just to keep that in mind when you're thinking about, what is it that we're trying to establish at the Human Rights Tribunal. You're not coming and saying they just didn't do X. Well, they didn't do X, and X is important to provide a meaningful access to education because. So you have to go further and really kind of link it. In education cases, again, we just tried to pull some quotes from cases here for you, but this is the applicant's onus. The applicant must demonstrate that the respondent, the school board, failed to deliver on the mandate and objectives of public education, such that the student was denied meaningful access to the educational services delivered by the respondents based on a protected ground, and in this case, and in most cases, it will be disability. So Nicole spoke generally about the duty to accommodate and the procedural component, meaning basically the brainstorming of different options to accommodate somebody. Now here's some quotes that in some portions of decisions that come directly from education cases. So the procedural component is concerned with the exploration of all the legitimate options to provide accommodations to the point of undue hardship. This is important, including a determination of the adequacy and or appropriateness of the proposed accommodations, if any. So what we're seeing here in this quote is the tribunal saying, look, if a parent puts an idea forward, or if there's an accommodation that's put forward by a parent, you need to consider it. You need to consider whether it's appropriate, whether it's adequate, and be prepared to explain why not to a school board. So this is this in my view expands the procedural component a little bit in relation to education cases, and something that you want to keep in mind if you're navigating a human rights application. What's also important to know in Ontario is that the two components that Nicole spoke about, the procedural and the substantive, if you fail in the procedural component, so if a school board doesn't engage in that brainstorming endeavor and doesn't look at the available options to accommodate somebody, that alone is discrimination. Even at the end of the day, there was no accommodation that they could have offered substantively. It's different federally, but in Ontario, under the Ontario Human Rights Code, with the way that our courts have ruled on this, that procedural breach is enough. The substantive component of the duty to accommodate from education cases, and this is from LB, and we'll get to what those decisions are in just a few moments, but I find that the respondent failed to provide services and supports to the applicant that were or should have been reasonably available, such as attendance, counseling, the support of a social worker, as well as in-school special education supports that were included in the applicant's individual education plan, and which could have assisted in meeting the applicant's identified disability-related needs. So once you do the brainstorming session, well, you better implement what's reasonable and what's a necessary accommodation at that point. And what's important to note here is the individual education plan. So it highlights when an individual education, an IEP, is being developed, why it's important to have parental advocacy at that point to make sure certain things get into that IEP, because it will be a guide as you move forward. So while not following the IEP could be a failure to accommodate, you're also not limited to the IEP. So you can ask for accommodations outside of the IEP, and that the duty to accommodate is still triggered there. And we see from the DB case a quote where the tribunal said, the tribunal can no longer accept the approach that as long as the substantive accommodations as recommended by the IPRC and IEP are generally implemented, the substantive standard of the duty to accommodate will be met. So there's your proposition for it from the DB case, something to keep in mind as you're moving forward. You're not limited to the IEP. From the Moore and Via Rail decision, accommodation is not a question of mere efficiency, since it will always seem demonstrably cheaper to maintain the status quo and not eliminate a discriminatory barrier. So we're not looking at what's easier for us. We're an overburdened school board. This is new for us. We've never done that. Those excuses shouldn't work anymore. They should have to look at what the accommodation is that's being proposed on an individual basis, applicable to an individual student, and implement it to the point of undue hardship. It shouldn't be, this is what we do, we're overburdened, etc. So we're going to talk about just a few cases. Generally speaking, in my experience, issues arise when a school board applies a cookie cutter approach to accommodation. So they just say, okay, we'll give you more time on tests, a quiet workspace, for example. And this isn't to diminish those forms of accommodation, but sometimes we need to look at accommodations that a school board might not be used to. And so you'll see some common themes here. And you'll also see in cases, in lots of cases, and most of these will settle, so you won't find decisions in them, but most education cases, as I mentioned, won't result in a decision. But we'll see the school boards quote one specific phrase from a decision. Just because a student does not succeed does not mean that a school board has failed to provide meaningful access to education. And that's from the JS and Dufferin Peel Catholic District School Board decision. And it's true, but the inverse is also true. Just because a student's passing doesn't mean that they're receiving meaningful access to education. So, whenever I hear that from a school board, I always put the inverse back and say, okay, it means nothing. Like stop kind of just putting these catchphrases forward, and let's actually look at accommodation here for this particular student in this particular situation. And so let's begin by starting with the Moore decision, which Nicole will speak about now.
Yeah, so this case is a Supreme Court of Canada case from 2012, and I do see that there were some questions in the Q&A box just around, what applies to different provinces versus just Ontario. So it is true that we're mostly speaking about the Human Rights Code in Ontario, and we can get into this more during the Q&A and talk about it. But I just wanted to respond to that, at least in terms of this case. This case is for Canada. I'm just going to give you a little summary. This happened in British Columbia. Jeffrey Moore was a child that lived in Vancouver, and at the same time as he was about to start kindergarten, the BC government were sort of doing a bit of an overhaul of their remedial supports in education. And one of the things that they ended up removing was this sort of added very intensive support for those with severe learning disabilities in schools. And so at the same time that Jeffrey was starting school, it became quite clear that he had a severe learning disability. And by the time he was in grade 3, he actually was suffering from migraine headaches, vomiting, anxiety, a loss of self-esteem, and other negative consequences. He had certain supports in place, but many experts and people that were engaging with him had said that's not enough. He certainly needs one-on-one support. He specifically had dyslexia, and the recommendation was that he have this intensive, individualized remedial instruction, but it was no longer available because the BC government had decided to stop it. So there was a school psychologist that met with Jeffrey and assessed him and ended up referring him to a special off-campus diagnostic center. And this was sort of part of a private school. So he ended up going to private school, and his parents paid for that schooling. Obviously, cases within legal systems take many, many years to complete. So by the time it reached the Supreme Court and Justice Abella was writing her decision, he was graduating from high school at that same private school. But obviously the parents had spent lots of money, and Jeffrey had also suffered a great deal before he was even able to receive that private school support. And so the decision's really interesting. It's actually quite an easy read in terms of legalese. So if any of you are interested, I encourage you to read it because it's quite a nice overview of even just how courts and tribunals think about these things, especially around failure or duty to accommodate, I should say, and sometimes the failure to accommodate, which is that they, just like Wade showed you, they think about what is the purpose of the Education Act? Like what is the purpose behind the service that this person is trying to access? And then are they really able to access it in a meaningful way, like everyone else is? And so, it talks a lot about the best interests of a student, which is recognized in the purpose of the Education Act. And those students with special needs can only really access these services in meaningful ways if they are provided with additional accommodation and support. And there's actually just a few things I wanted to read to you from the case to help describe that when we talk about the duty to accommodate and how important that initial inquiry is. Just like Wade was saying, it's so important, even if they can't actually provide the accommodation in the end. If they don't think about it, then courts, including the Supreme Court, are not interested. And so Justice Abella says at paragraph 43 of the Moore decision, thinking about the tribunal who first considered it in BC, she says, the tribunal found that when the decision to close the diagnostic center was made, the district, which is an area in Vancouver, the district did so without knowing how the needs of students like Jeffrey would be addressed, and without undertaking a needs-based analysis considering what might replace diagnostic centers or assessing the effect of the closure on severe learning disability students. The tribunal noted that at the board meeting that they had where they decided this, the minutes actually stated all trustees indicated in this discussion that they were adopting the bylaw as it was required by legislation and not because they believed it met the needs of the students. It concluded that the doctor who'd was in charge of the superintendent of the schools and the district in general, that he did not know how many students would be affected by the closure. In fact, on the day of the board vote, the district's assistant superintendent and the coordinator of student services informed that doctor that it was too early to know precisely how the needs of high incidence students will be addressed in the absence of the diagnostic center. So basically it's just, and it goes on for paragraphs actually to consider all the other failures of why didn't they think of this, or what, they obviously weren't even thinking about how this is going to affect students. It was based purely on cost. And so the court found that indeed Jeffrey's right to access meaningful education had been infringed, and surely they had failed to accommodate him, and the tribunal had originally ordered that his private school tuition be covered, and Justice Abella agreed with that. The Supreme Court said that was a fair and reasonable decision. In addition to, I believe it was $10,000, Wade, you might remember, I think it was $10,000 in general damages that Jeffrey received as well.
Thank you. And I just want to point out that we do see the questions popping up in some open questions. We're not ignoring them. We will answer them. I think we'll probably answer some of them when we get to our scenario. And for those that we haven't, we'll respond directly to them. So the next case we just briefly wanted to highlight is the LB decision. So this is a post-Moore decision. So it's in 2015, and it was against the Toronto District School Board. So LB was a 14-year-old student who started grade 9 at a large collegiate institute in the board. And prior to starting high school, LB was diagnosed with multiple disabilities, which included learning disabilities and mental health disabilities. So for September 2012, when LB started grade 9 to April 2013, so almost, most of the way through the school year, there were issues with accommodation. LB did not have access to the supports that were set out in his IEP. So after approximately 7 months of failing to accommodate LB's mother made the decision to remove LB from school and enroll him in a private boarding school in Ottawa. There was a sports component to the school, and there's a reason for that. I mean, a lot of people in the criticism of LB say, okay, well, this was a private sports school. I mean, I think that's unfair. I think sports was a component, but that was really something that would keep LB engaged in the school. And so ultimately looking at, well, what did the Toronto School Board do during that year? Was it a failure to accommodate over those 7 months? The tribunal found, yes, it was. And so they found discrimination and they ordered $35,000 in general damages. But they refused to order the special damages to pay the cost of the private school tuition for the residential school in Ottawa. And they found that the reason they refused to provide that tuition was they found that it wasn't the only option available to meet LB's needs. So LB appealed that decision. It's not really an appeal, it's a judicial review. You're asking the divisional court to look at what the Human Rights Tribunal has done and say, is this an error here? In the divisional court, when they looked at this case, found that the board did not abandon LB, but there was a period of time in the grade 9 year, those 7 months, that the services were not forthcoming. And on that basis, they distinguished the facts from more. So wasn't abandoned. There still was something they could do, but they recognized for that 7 months they didn't do enough. And the court said that while a school board should accommodate a student with disabilities to ensure access to public education, a parent should not deprive a school board of that opportunity by resorting to private school education and expecting to recover the full costs of doing so. And the court said, okay, after you took LB and you put him in the residential school, LB's mother should have inquired with the board even after that to see if it was in a position to deliver the necessary services. And because she had not engaged, the tribunal, the court said, well, the tribunal's decision not to give the private school tuition cost was not unreasonable, meaning it stands up. The court did find, however, that for the grade 9 year, it was reasonable for LB's mother to have acted in LB's best interests in enrollment in the private school because up to that point, there was a failure for that year. And they awarded the private school tuition, but only for the remainder of that grade 9 year. So we see a couple important things from this case. The duty to follow up with a board after a student's moved out into a different board if you're asking for the private school tuition is the main takeaway from that case. But notably, we do see private school tuition ordered, which I think is a big step in the right direction. The VJ versus Thames Valley District School Board case. So this is a case where a student struggled through grades 9 and 10. And for grade 11, the student went to the Gow School, which is a specialized residential school for children with dyslexia in New York. And the remedy sought at the Human Rights Tribunal was private school tuition for the Gow School for grades 11 and 12. I was involved in this case, and I'm not saying anything about this case other than that's not already published online in a interim decision of the Human Rights Tribunal, which is a citation that you see. And just to be clear, I was acting for the applicant in this case. And by the time we commenced the merits hearing, which just happened in October of 2022, we were before Vice Chair Ava Nichols at the Human Rights Tribunal. And Vice Chair Nichols is a well-known vice chair, has extensive experience related to learning disabilities and dyslexia in her past involvement, and has been a longtime vice chair at the Human Rights Tribunal on the education side of things. But by the time we got here, this merits decision, Vice Chair Nichols had issued the DB decision, which Nicole will talk about next. And I just want to tell you one paragraph from that decision where she says, I'm not prepared to order future private school education funding for DB. Notwithstanding the divisional court's decision in LB, which is the case that I just spoke about, where the respondent was ordered to pay a limited amount of compensation to the parent for the cost of her son's private school attendance, I am still of the opinion that public school boards are not and should not be ordered to fund private school education, especially where such attendance is in the future and the cost amount is speculative. So, when you're going into a hearing where you're seeking private school tuition, that's not a paragraph you want to read from a very recent decision from your judge or adjudicator. One thing to keep in mind is that to date, the Human Rights Tribunal has not awarded private school tuition as a remedy against a school board, no matter how drastic the failure to accommodate. So we know from what Nicole said that the Supreme Court has and more, and we know in the LB decision, the divisional court allowed it to some limited extent for the rest of the grade 9 year, but it's never ever come from a decision of first instance at the Human Rights Tribunal. So going back to the VJ case, the dispute between the parties for this interim decision, which means decision about a step in the process, was whether or not private school tuition could be awarded as a remedy. Now, I argued certainly it can be. We have more in LB, and they tell us it can be, and we have nod from higher courts. And the vice chair in this case agreed and said, It is possible, but here's the test. Establish prima facie a prima facie case that the school board did not provide the supports necessary to provide access to a meaningful education, step 1. The school board fails to establish undue hardship, step 2. But then the decision to withdraw a student from the public school system will depend on whether there was reasonable alternatives available in the circumstance, and it does not relieve the student of an obligation to inquire whether the necessary accommodations could be provided at a future date. So a bit of a roadmap of sorts, but also an acknowledgement that private school tuition can be ordered by the Human Rights Tribunal of Ontario. And I'm talking about Ontario a lot. This will apply to other provinces as well. So generally remedies under different human rights legislation are very similar. They have the ability to remedy a code violation, which can include reinstatement to employment. It can also include funding things where you have to send a child out of school to private school tuition, therapy. They're all possible remedies. But what we also see here is the tribunal telling us the threshold will be high.
Okay, this is me. So another case that we just mentioned a brief quote from is DB and Toronto District School Board from 2021, another Human Rights Tribunal of Ontario case. And this, again, has a lot of similarities to Moore. So DB was an 8-year-old child. He was diagnosed with autism spectrum disorder at a very early age. It was before he was 3. And he, his autism was deemed moderate to severe, and he was also nonverbal. And so while he was unable to communicate that way, there were other means that allowed him to communicate, such as the alternative augmentative communication and touch chat. And so he hadn't yet attended school. When the parents filed the application, he was attending a specialist private center that was offering this applied behavioral analysis programming to him to provide added support and help him with communication. When he was 4, he was then eligible for funding for these communication services that he was using, and that was through the Ontario Autism Program. And so he was receiving 32 and a half hours of comprehensive ABA, this applied behavioral analysis therapy. He was receiving that 32 and a half hours a week. And then when he reached the age that he could go to JK or SK, his parents just chose to keep him in a private center so that he could continue to receive that. Now, around the same time, the provincial government announced that they would change the Ontario Autism Program in February 2019. It was anticipated that the funding for ABA would be eliminated at the existing level. And so DB's parents began to explore educational options that would be available through the Toronto District School Board. The parents really did expect that he would be able to be enrolled in a public system and continue to receive his ABA programming that he needed. However, then they realized the school board wasn't going to provide the ABA services in the school setting. And so they filed the application at the Human Rights Tribunal. And what they originally sought, what the parents were asking for in terms of a remedy was for the school to provide the ABA on a full-time basis, and provide ongoing direct behavioral and communicative support throughout his school progress. And they said in the alternative, if that couldn't be done, that the tribunal order the Toronto District School Board to provide and fund full-time comprehensive ABA that would be administered by another qualified professional. So as you heard that quote from Wade, the tribunal found that they couldn't order for future costs that the family might incur for this service. The tribunal did find that the respondent, in this case, Toronto District School Board, that they failed to adequately and appropriately consider DB's disability needs, and also failed in its duty to offer meaningful access to an education to DB by its failure to consider both procedurally and substantively the accommodation needs of students, this student. What they ordered then was $20,000 in general damages, and that was it.
So this is a case here that we're just going to touch on very briefly. I think Nicole's going to explain to you a little bit about grade changes, but we don't want to go into this case or really summarize it. We just want to give you the principle so you know it exists if you're advocating for well, either grade changes or an application to university or something for that results in grades that are not reflective of someone's ability due to lack of accommodation.
Yeah, and sorry, wait, I'm having a hard time pulling up my notes on this. Do you mind just jumping in here?
Yeah, no problem. So this is a case where back in the day, an individual had was engaged in education, and the grades were not reflective of, there was a disability that was diagnosed after the fact. So very poor grades were obtained, and there was an undiagnosed disability at the time, no one was aware. And then there was a diagnosis. This individual applied to post-secondary education. In this case, was at the Human Rights Tribunal and then went to the Divisional Court, and it talked about what are the obligations of post-secondary schools with respect to grades that aren't reflective of somebody's ability. And it talked about looking at other factors and not giving those grades quite the weight that you would normally have in the admission process. So something that we just want to flag, but we don't want to spend a lot of time on. I want to stick to I think the core of why we're here and get into some of the scenarios and hopefully answer some of the questions that are posted, the very good questions. So dealing with school boards' responses. This is a procedural issue, and it really arises from situations where a parent is self-represented, so there's not a lawyer, and they're relying on things from articles, for example, or well-known facts that most of us know but aren't in evidence. Typically, courts, tribunals, they only rule on the evidence of that case. And so they say, well, look, that might be true, it might not be true, but it's not an evidence before the tribunal, they can't rely upon it. And the self-represented person says, well, why not? We all know it's true. And one of the benefits of the Human Rights Tribunal of Ontario, and this comes out of the LB decision, is that they can take judicial notice. So they are a specialized expert tribunal. And relative to a court, this tribunal has a broader scope in considering and taking into account social facts and context in making its decisions. And so when you have somebody like Ava Nichols at the Human Rights Tribunal of Ontario, who has a considerable background in learning disabilities and dyslexia and was involved in it in her prior work, and is now sitting as an adjudicator with considerable experience in education law, she knows more than most, right off the bat as your adjudicator. So that's one of the perks. You have an expert adjudicator, and that expert adjudicator is able to take into that the social facts and the context in making her decision. So, this is something that you can raise and push back on when you're at the Human Rights Tribunal, should you ever get to a hearing. Another is with respect to private school tuition. Well, it's a burden on taxpayers. It's a preference, not a need. It's not a service. So, and I put up Ava Nichols' decision from the DB case where she says, I'm still of the opinion that the public school boards are not and should not be ordered to fund private school tuition. In my view, and I think there will be movement here. So we have had cases before, Ava since DB, and I think there is a willingness from this tribunal to consider private school tuition in the right circumstance. And part of the pitch that you'll want to make is that nobody believes that public school boards should be required to fund private school tuition as a general principle. It's simply unsustainable for a publicly funded system. But I think we disagree on why the path to prevent the cost of private school education or why it shouldn't be ordered. It shouldn't be ordered because schools should accommodate students with disabilities and provide meaningful access to education. It should not be provided just because it's a tax burden when schools don't provide it and someone's not receiving meaningful access to education in order to reach their potential. So I think another argument that could be made is Bill 82 made special education mandatory in Ontario, and now we shouldn't be trapped in a system where special education is mandatory on school boards, but they're not going to provide it. There's no reasonable alternatives to exit that situation, and they're stuck there. In a situation where it's gone on long enough, access to private therapy in addition to schooling or a private school, for example, should be reasonable alternatives that are available. And if people don't want a publicly funded system covering private school education, then meet your obligations and provide meaningful access to education. Another common response from school boards is what the family was seeking was beyond the scope of the services of education. So applied behavior analysis, for example, was found not to be a service, but a therapy. Now, what I'd say here is focus on what the need is and why it's necessary to allow the student to have meaningful access to education. So let's use teaching in reconstructive language, for example, an Orton-Gillingham system, or I think one of the questions was also, just taking a look here. There's a lot of questions. I can't find it, but there was one about a specific accommodation, something else. So if we use reconstructive language, without an ability to understand what's being taught, a student's not going to have access to all facets of education. So things will get worse. We see the Matthew effect, and there's a quote up there, but essentially, if someone's not getting the assistance they need, it's going to start to permeate to other aspects, and their ability will decline. What really resonated with me in one of the cases I was involved with was a client who said, if you can read well, a science test is a science test. If you cannot understand language, a science test is a literacy test. So break it down into the possible. You're not going to ask a public school to become a specialized private school like the Gow School, but show the ability to have one teacher trained in a reading comprehension or remediation programs. Don't let school boards frame the issue so it's something so extravagant. You're asking for something that they just can't provide. We're not going to become this specialized private school. What about one teacher being trained in this, in reconstructive language, for example? So break it down into the possible, show the need for it, and don't show the need for it because it's something you want. Show the need for it because it's necessary to enable the student to have meaningful access to education. We see in the LB case, the tribunal said the private school education chosen by SB for her son was not fully determined on the specific recommendation of the professionals involved, nor is it a school that specifically focuses on remediating disabilities of the type that LB has. So again, if you are going to at some point look at private school education, make sure it's something that is providing that service and that it's based on expert recommendation. So you can say, unlike the LB case, this is something that's supported by the experts, and it is something that's going to be provided that this school board simply, time and time again, has failed or refused to provide. We tried to work with the family, but the parents were too aggressive, and it interfered with our ability to have meaningful dialogue and accommodate the student. I've always struggled with this argument because I think if you're saying, well, the parents are aggressive, we don't want to accommodate the student, basically you're saying we've discriminated on the basis of family status because you're accommodating the student even though you're working with the parent. So I've always taken issue with this type of argument for that reason. And also, nobody knows their child better than a parent, and their parents are invested in their child's success. And so, I often find that parents aren't given the respect in that process. They're seen as kind of obstacles to a school board as opposed to the best partner to work with for that student. The case law has really developed in this area. So we see in LB, a parent's fierce advocacy for his or her child must not and cannot prevent a school board from accommodating the child's needs to the point of undue hardship. In DB, the tribunal said parents do not have the right to dictate the accommodations or to expect the perfect accommodation, but they do have a right to be fully informed about the options available, to engage in a discussion regarding the safety of their child at school, and to expect that any identified safety needs are considered and accommodated. In LB, parental conduct or lack of parental authority cannot be used as justification for not meeting an exceptional student's needs. So the case law really has developed here, and I think at this point we recognize these aren't valid arguments, but they are often raised by school boards in different situations still. Another common position we see from school boards are the family truncated our ability to provide accommodation to the student. We would have been able to do that within a specified time frame. So this was really what was found by both the Human Rights Tribunal and the Divisional Court in LB. This is really kind of a challenge because at what point is enough enough, right? If you look at the VJ case that we talked about, in that case, the student was in a school board for grades 9 and 10, and they were saying, well, you failed to accommodate me. So should we now go grade 11 and 12? Half of their education is over at that point. So, I take issue with this. I think, frankly, it's an error in law. And I think what tribunals should be looking at and what you should be arguing, should you advance a case where there's been a long failure of accommodation, and is, look, on a balance of probabilities, is the school board going to accommodate my child reasonably so they have meaningful access to education or not? The test shouldn't be, could they do it tomorrow? Well, sure, anybody could do it tomorrow, but if they haven't done it for 2 years, they're probably not going to do it for year 3 and 4. And are you willing to take the gamble that I'm going to leave my student in that school, leave my child in that school when they're not getting the education they need because of the failure to accommodate? It's a completely bogus position, the truncated argument position. And I do think we will see tribunals think about this more carefully as these issues are raised and say, there's a tipping point. At some point, enough's enough. And the best interest of the child prevails, and not what could a school board possibly do tomorrow if it changed its act. So, something to keep in mind and to advance as you move forward. I'm going to try to answer some of your questions here. We have 2 frequently asked questions that we wanted to present to you, but we'll just take a moment to answer some of these because they're piling up. So let's look at, so Cheryl, you asked, does this apply in Manitoba? Generally speaking, human rights principles apply across the provinces. We're talking really about Ontario, but I've practiced before the British Columbia Human Rights Tribunal and Prince Edward Island. Human rights principles are the same, although the processes might be slightly different. And Alicia, feel free to join us here. I know Alicia is not a lawyer, but Alicia probably has far more knowledge than both Nicole and I about many of the questions that are being asked. So please jump in with us here.
Well, I don't know about that. I will definitely jump in. I've been following the questions and I've been sort of taking notes about themes that are coming up. So I will ask you a few of those. One that popped up that I thought was interesting was just going back to the notion of the 1-year window. So someone was asking if you could clarify that a little bit. Is that 1 year from the last incident of discrimination, or 1 year from when you requested the accommodation? Like, how does that work?
Yeah. Oh, sorry. Wait, you want to go ahead,
Nicole?
Yeah, I was going to say, yeah. So it is 1 year from the last date of discrimination. The only thing I'll say about that is that sometimes what ends up happening is there's a period where there's a failure to accommodate, and then there's a big gap in the middle, and then there's more issues and discrimination. If you want all of that considered, the closer together it is, the better. If those things are more than a year apart, it's very hard for the earlier things to be kept together with the new stuff. So really 1 year time limit is quite strict. Like Wade said, it's very hard to find exceptions with that, but it's generally from the date of when the last incident of discrimination occurred.
There are ways to get around that. So it is a strict timeline, but if something changes, for example, you can kind of reopen that limitation period. And I've always taken issue with the point, okay, well, we haven't accommodated your child for 1 year and 1 month, so you're out of time. There's still the obligation to accommodate in education. So I think in terms of education cases, you'll see Section 4 be a little bit more relaxed. And really, if you're not sure, if you've requested an accommodation and a school board has said no or just not done it, and you're past the 1 year mark, go get another opinion or another medical opinion or another expert opinion. Ask for it again with a little bit more information, and that in some situations can tend to reopen the limitation period. So while it is strict, there's ways around it that you can look at. So if I don't normally like saying consult a lawyer because it seems like lawyers are just trying to get work, but with respect to limitation periods, consult a lawyer because they are tricky.
Thanks. Another question that someone actually sent in ahead of time, and I see sort of reflected in the chat again, is around the type of services that would count as effective accommodation, or does I guess I should say, does the accommodation that's provided need to actually be effective for it to count? So specifically what people are wondering about is, in a lot of schools, school boards will provide a program that is not necessarily, or that doesn't have evidence to show that it is effective for students with disabilities. Specifically, this was mentioned in the Right to Read report, There were a couple of programs, reading recovery and level of literacy intervention, were specifically named in that report. So what parents seem to have happening is that, the school board is saying, well, we are providing a service for your child. We put your child into this program, even though the program is not one that's shown to actually be effective. So in that sort of case, would that be considered discriminatory, or is that something, how would the parent address that?
Yeah, I think that's a failure to accommodate. And that's kind of what I said in my experience. There's kind of these cookie cutter approaches that they try to fit people into. If it's not working for, you can have different programs. And if you're offering one of those programs to a student, but it's not providing meaningful access to education, well, then the program shouldn't be offered any longer because it's not working. And you have an obligation to do something else to provide meaningful access to education. So, yeah, I think that's part of the problem. I think it's, school boards taking the position that they're overburdened, there's a lack of funding. Well, that frankly and respectfully, that's not our problem, right? Your obligation is to provide meaningful access to education. So don't just create cookie cutter programs that you try to fit everybody into these different kind of lanes that they might not fit into. Be creative. And, that's where a lot of the burden falls on parents. And I've seen parents really burnt out from this process because they're trying to gather the information themselves. It's difficult to navigate. They have school boards throwing up obstacles and seeing them as the problem. I feel for parents in this situation, but I do think there's try to figure out what your child may need by consulting with experts and make that suggestion to the school board. And then when you get kickback, which most of the time you will, you can look at the human rights system and, or like, I know there's groups and there's kind of advocacy and working together in social media. There's lots of ways to address issues, in my view, that are better than the legal system. And so, continue to kind of advocate in that way. But just to answer that very specific question, should the system not be working? Should they keep the student in whatever that program is? It's a failure to accommodate. I think it's simple.
That's great, thanks. And in there, you were talking about, in that response, just how burnt out a parent can get when advocating for their child, which I completely identify with. And there was an interesting question in here that was a parent who is also an employee of the school board, wondering, how do you navigate that piece of advocating for your child when you're also, potentially facing employment repercussions for being that parent that needs to be aggressive in advocating? Do you have any advice for that person?
Yeah, so in a situation like that, typically it's, in my view, one thing you can do is retain a lawyer to advocate for you, and the lawyer can phrase the letters like, I have advised so-and-so that this is a failure to accommodate. So, you try to protect the parent to the extent that you can as a lawyer by making it look like, you're the big bad lawyer and you're giving this advice, and this is us pursuing this and giving the parent this advice. Another thing to consider, though, is that you're also protected in employment from discrimination. So to the extent that this actually matters, you can bring a reprisal application, you can bring a family status application for, or for raising your child's human rights. So you do have that protection. Practically speaking, will that stop a school board from reprising? Who knows? But there are options available to you should it happen. My advice in situations like that, and this happens more frequently, I probably had 3 or 4 situations like this in the past, is let the lawyer be the bad guy and kind of make it look like they're making those suggestions.
Thanks. Another question that was in there is around what to do when the child doesn't have an official diagnosis of a learning disability. So the question is about a child who's in grade 3 and can't read, but doesn't have an actual diagnosis of dyslexia, but appears to need the same supports that a student with dyslexia would need in terms of systematic and explicit phonics instruction type program. So in that case, if there isn't an official diagnosis, what can the parent do, or what is expected for the child?
So the Human Rights Code protects not only disability, but under disability is also perceived disability. So it could include somebody who's undiagnosed at that point, or if there's a perception that there's a disability or disability related need. In my view, the obligations of a school board are the same as if somebody were diagnosed. Maybe it's a little harder to figure out what the accommodations are because, with a diagnosis can come more information about what may be needed. But I don't think that alleviates the school board from having to provide the accommodations in the interim while that process is underway.
Sure, that would seem reasonable. In there as well, someone was following up with that and saying, well, what about if the school doesn't even recognize that the child is struggling because their own assessment systems are so poor? If the parent perceives that there's a struggle, but the school doesn't recognize it, where does that fall into place?
Yeah, that's tricky because I think that happens more often than not. I think a school board will say, well, maybe this is just a child's ability and you want more for them, but they are receiving education and this is their ability and you're expecting perfection and, let the child be a child. Like you see those types of arguments that are raised. I think you probably want to fall to the extent that you can on experts or show that in different situations, their ability is exceeding that which is expected and being received in school. So try to show the differential treatment and identify what's causing it. I mean, I don't really know how to answer that better than that answer because it really will be very individualized. But you do see that, and that's where someone says just because a student's isn't being successful doesn't mean that they're not being accommodated, right? You see those arguments raised.
Mm-hmm.
And that just made me think of another point, which is just to try and keep most of your communications to email or, just to create a paper trail, because I think that will help too if you do have to pursue the issue legally, rather than saying, well, we had these conversations, or if you do have conversations, just follow them up with an email. This is just to confirm what we discussed today, which is A, B, and C. I think that would help too.
I will say on that one, I always tell parents that too. I always put everything in email. And I find very often that school administrators, or not so much teachers, but especially when you escalate to the principal superintendent level, they refuse to respond to our emails, right? They'll pick up the phone and call. So how do you deal with that situation when, you've written the email, you've asked for the response, and then they refuse to actually give you a written response?
Yeah, I mean, my thoughts are just that, as soon as take notes during the conversation. First of all, your notes are still valuable and important, especially if you date them. On this date, I spoke to so-and-so. But I like to, if that happens to me, I just follow it up with an email. I say, further to our conversation today, where you stated that you were going to look into this assessment, you were going to provide A, B, and C, and then we were going to follow up next week. I'm just confirming that all of this is accurate. And if I've missed anything, please let me know. Send it off. And then you have a paper trail. They can correct anything if they want. But that helps to create the record.
That's a good point. A couple of other questions that we have in here are about parents getting together and filing complaints. So there was something in the chat that has just flown past me about there was a case in the United States in Berkeley, California, where there was a class action lawsuit where a group of parents were successful in getting specific programs removed. I think it was settled, but they were successful in getting specific programs removed and having an outside expert come in and oversee the school district's systematic change to reading instruction. And then someone else asked if parents should get together and try to confront the school board, but it's sort of to get together and ban their complaints together. So if you could sort of speak to that class action idea or a group complaint, your thoughts on that.
Yeah, it's a good point because in one of the questions that was just asked, which feeds into this, I think was from Pat, and the question was, well, what if we don't have money for a private lawyer? What can we do? We don't have money for private testing, and everybody's in a different, socioeconomic or financial situation. So I think banding together is important. Cases at the Human Rights Tribunal are not binding. So it means that one Human Rights Tribunal adjudicator could decide a case and another one could decide differently because that's not binding on that adjudicator. But practically speaking, any administrative tribunal in Canada wants consistency. They want people to understand what the law is. And so you can do one of two things. You can have a case that you want to kind of be a test case to set the trend at that Human Rights Tribunal. And in that situation, you can have groups intervene, like Dyslexia Canada or other groups. They can intervene in that litigation to advance a position for all of their members or for their area, and they can seek that intervener status. So that's one way to do it. So have a test case, push something forward, marshal all of the evidence, try to find a lawyer to do something like that pro bono. If it's a test case that's going to benefit everybody or a large segment of the society, you'll often find a lawyer who will do pro bono work for something like that, as opposed to one-off cases. So banding together is important. Class actions are probably not a practical viable route with respect to education law, but individual human rights applications can be enjoined. So for example, if we have a school board that's not offering a certain program that's needed for children with a particular learning disorder, learning disability, then you can file 5 applications, say, against that school board. And if the facts are close enough, you can say to the tribunal, we want to enjoin these applications, which means connect them together and let them be heard together on the common issues. And the tribunal will decide whether to do that or not, but there's efficiency purposes to that. So those are options, but my personal kind of recommendation for something like that when you're trying to advance is to have that test case, have people kind of work together on it, have interveners, and try to advance the law in that way, in a way that it will be applied moving forward to help everybody.
That's a really good point. So when parents, if parents were considering joining together, do you think it would be best if they were all from the same school board, or, could it be sort of against the province of Ontario or something like that for a larger issue, or would it be better to have them more closely related?
I think the same school board. So the tribunal is more likely to consider that type of argument if the facts are very similar, it's the same respondent. When you start to have different respondents and different applicants, something like that can become unwieldy from a litigation perspective. One thing that could happen is there's a number of applications against different school boards, but it's all based on the exact same issue, like the right to reading inquiry, and whether that needs to be implemented in schools or not. And I know everyone's waiting on the Ministry of Education, but something like that, you could have the tribunal kind of consider as a preliminary issue the viability of that argument. Just like what happened in the VJ case, right? The respondent in that case took the position, well, private school tuition can't be ordered. But we said, yes, it can be. And we asked the tribunal to decide on this legal issue, and they did, right? They might not always do that, but I think just working together, seeking legal advice where necessary. And like I said, I realize lawyers are expensive, and I know there's legal clinics, but there's not enough. And so a lot of people are lost in this system, and it's really important for them because it's their child that they're advocating for. I understand that. I don't mean to diminish that in any way, but I think working together, banding together, and as a group, asking a lawyer to provide some advice and think strategically, whether through Dyslexia Canada or another umbrella organization or whatever, how are we going to advance this issue of law to help everyone in this area is the way to go. So organizing discussions, even stuff like this, following each other in social media, kind of enhancing one another's voice. Reputational impact on school boards matters. You'd be surprised how often kind of a tweet can get somebody's attention and someone say, oh, look what they said about our school board, let's look into this. It matters and it works. Nicole and I are both active on social media, many lawyers aren't, but follow each other, enhance their voices, show the advocacy and support one another, because it's lonely when you're a parent advocating for your child and you're against a school board that has taxpayer dollars that's, I'm not speaking generally, but sometimes just trying to cover their butt and make themselves look good in the process, right? That is a really draining process.
Yeah, that's a really good point about, an individual parent facing a school board. I joined a parent in Nova Scotia just to be there to support her because she was entirely on her own in her human rights tribunal case or commission hearing in Nova Scotia. And it was just her and I and 3 lawyers for the Halifax Regional Center for Education, so we were thinking, this is ridiculous. Like, she can't get any legal aid or anyone to support her. And there are 3 lawyers sitting here for this entire thing. Like, how much is this costing the Halifax Regional Center for Education to just deny this one child some reasonable accommodations? Seemed a little bit one-sided. But I was happy to show up for her, and it's nice for parents to show up for each other and to support each other through this process, because you're right, it can be very, very lonely. And there is a question there as well about the length of the process and really the endurance factor. So someone was asking about the backlog at the tribunal in Ontario and what are parents supposed to do while they're waiting for their case to be heard.
Yeah, that's a good point. There is a significant backlog. I think at this point, we can safely say it's probably well over 10,000 cases. So what used to, the internal standard used to be 1.5 years to have your case filed to get to the merits hearing. Now, Nicole and I have files that have been dwindling for 2 years before getting to mediation. We mediate on the file now. We've been doing a number of mediations, and they're telling the applicant 2 to 3 years to a hearing. That's a 5-year process, right? Think about that. If someone's in grade 9 and not being accommodated, they're going to be finished high school by the time their case is heard. So I take the point that, is the Human Rights Tribunal really a viable option? Not right now, it isn't, frankly, but they do prioritize education cases, and they historically have. So education cases were always pushed to the forefront because the tribunal recognized that that there's an urgent need because they move from year to year, for example. And they also had a specialized education unit. So even Nichols and there was a number of other adjudicators who had a real specialty in education were assigned to hear these cases. They'd often give a full day mediation. So before they were prioritized, the tribunal is working, obviously, to get rid of its backlog in various different ways. So, in my view, it can only go up from here. So we can only see improvement. So keep an eye on it. But just because you file an application doesn't mean you just need to sit there and wait, right? You continue to advocate with the school board. They may be upset you filed an application. More likely, they're going to be scared and start to cover or document at that point. But continue to advocate with the school board. There's media attention that you can get, and like I said, it does matter. So social media, all of those things are things that you can be doing in the meantime. And so I wish I had a better answer than that, but unfortunately that's the system we're working in.
And I'll just add 2 things to that that may or may not help. But one thing is that sometimes, again, this does require a lawyer, but sometimes you can be strategic and even send a demand letter first before you file the application or at the time that you file the application to try and get things moving, especially if what you're looking for isn't money, but it is for them to accommodate, for them to provide the service that you're trying to get for your child to meaningfully access that education. So sometimes that is a good tool available to you and more cost effective in terms of legal fees. It's not going to cost you that much for that process. And quite often lawyers will even give you a flat rate rather than, charging you hourly and on end. And then the other thing I just wanted to say, very rare, so don't count on this, but if there's like a very dire circumstance with like an urgent need that this needs to be addressed now, this is an emergency, you can file a human rights application and ask for what's called an interim remedy. They are not granted easily or readily, and they are an incredible amount of work. I've made an application myself, which was denied, and it wasn't an education system. But what I wanted to say is that education cases for interim remedies are where we usually see the tribunal grant interim remedies because it involves children and because it is time sensitive. So keep that in mind. If there's like a real dire circumstance, you could consult with a lawyer to see if it's worth it.
Excellent. That's great. There's one thing that you said earlier around, you made a comment about the school boards are all waiting on the ministry now after the right to read. So I did have a question about that because in reading the right to read report, there's a lot of recommendations in there that are directed at school boards, not at the ministry. They're things that are within the school board's responsibility. But we do hear of many school boards that really are waiting and really not doing anything. So in those boards where the school boards are using that defense that we're just waiting for the ministry to tell us what to do, is that something where parents could get together even if they weren't necessarily, didn't have kids that were necessarily impacted themselves at this point? Is there any chance in those boards that, I guess what I'm really asking is, how much does that report actually weigh? And the things that are in that report, like, how much can we hold school boards responsible for doing those things?
Yeah, that inquiry was substantial. And I think, what I'm saying here is partly anecdotal from cases I've been involved in, but what I think you might see the Human Rights Tribunal do, the Human Rights Tribunal of Ontario for this inquiry is say that by not implementing these, it may be a failure to accommodate in an individual case. So what should be the focus, in my view, is taking that report, taking those recommendations, and advancing a case all the way to a decision that makes where at least part of the argument is by not implementing these and by waiting after you have this report, for whatever the reason you might be waiting, right? Some of us believe the ministry's going to come with some comprehensive thing that they're going to roll out to school boards or whatever. But by waiting, there's students who are not receiving accommodation, and these accommodations have been identified through a report, and it's discrimination. And what you might get is a human rights tribunal agreeing and saying, in this case, for this particular student, these should be implemented. Now, that's all they can do. They can't order it kind of, well, that's arguable, but I don't think they can order it kind of broadly sweeping. But that one case where they order it will probably be enough to start that trickle effect where we see these start to be implemented in a quicker manner. And it's really disappointing that, there's almost resistance, in my view, to implementing the recommendations rather than saying, okay, a lot of work has gone into this, we're going to implement it. Why wouldn't you implement it? So
Especially some of the simple things. Like, I don't know if you noticed, but the very first thing in the executive summary was just use the word dyslexia. Just do it. Like, why not? Why can't we say that? Put it in policy, start using it. But even now, a year later, it's not showing up in official documents. It's not showing up on IEPs. Parents aren't able to get that word used in official communications. It's very, still challenging. But there were some questions in there as well about things happening in other provinces. So I can just give a quick update on that, in that the Human Rights Commission in Manitoba is doing a special project. It's a similar question to the inquiry that happened in Ontario. And I believe that they're sending out a parent survey soon, which is very similar to the one that was used in Ontario. Saskatchewan, their Human Rights Commission has, for the last year and a half or so, been doing a special project looking into the same issue. So they're going to be writing a new policy or report about it as well. It's a slightly different process in Saskatchewan, but it's happening in both of those provinces. So if you're joining us from another province, and you would like to bring those issues forward to your Human Rights Commission, I would very much encourage you to reach out to us at Dyslexia Canada, because we would be happy, more than happy, to support you in that. And on that, we are at our time of 8:30. So if either Wade or Nicole, if you have any last words or any questions from the chat that you'd like to address before we call it, you're welcome to.
Well, thank you for the opportunity to speak tonight. I always appreciate this because there's so much need, and this is an opportunity to kind of hit as much need as possible for us. We both have busy practices, but if you do create a group, I see a lot of the comments here, how do we build allies? How can we get into a group? If you do create a group and you have questions, Nicole and I would both be happy to answer those questions for you, as you go forward and you start to work together to advocate as a group. We would be happy to be involved in that and to help.
Definitely. Thanks for having me as well. It's been good talking to you all. Sorry, I can't see your faces.
Wonderful. Well, thank you both again so much for volunteering your time to come and speak with us and answer our questions. For those of you who are watching, who are interested in how do we find each other and how do we form a group, you can find each other through Dyslexia Canada. We are happy to assist with that. You can get in touch with us through our info line, which is info@Dyslexia Canada, or find us on social media. Follow our Facebook page, or join our Community Connections program, which is where we do have live discussion, peer support groups happening once a month. Our next one is this week on Thursday. So you're all welcome to join that discussion. That is not a webinar, that is a large group meeting, and you do have a chance to connect with other parents directly there. So thank you, everyone, and have a great night.
Thank you. Take care.
Bye.